And thank you very much, Roy. I think the last case is going to generate quite a lot of interest and excitement. So for the participants who are with us on this webinar, please do remember to post your questions in the Q&A feature, and you can upvote questions too. And we do have a couple of questions that we've left actually to the end deliberately. The question on reasonableness is a particularly interesting one, and I promise we'll get to it. But first, let me just read out the last case, which is the case involving Dr. Chan and Mr. Fong. So Dr. Chan is a GP working at a polyclinic. There is a long queue of patients every day, and doctors are advised to keep consultations to 10 minutes to avoid excessive backlog. When he is able to, Dr. Chan spends more time with his patients to ensure quality care, but this is not always possible. On a particularly busy day, a patient, Mr. Fong, is in the clinic with respiratory symptoms. He's a manual worker who operates heavy machinery. Dr. Chan diagnoses Mr. Fong with an upper respiratory infection and prescribes medication, which rarely has the side effect of drowsiness. However, due to the busyness of the clinic, he does not question Mr. Fong about his line of work, nor does Mr. Fong inquire about it. Due to the drowsiness, Mr. Fong is later involved in an accident at work and subsequently makes a claim against Dr. Chan for failing to advise him about those side effects of the medication. So, to get the ball rolling, again, question one is kind of a liability question. It's quite an interesting question in terms of Dr. Chan's and whether or not he would be liable for failing to advise on the specific risks. But perhaps if we just take a step back, I wonder if the first question we should be asking is about the standard of care owed. So maybe this first question to Vanessa, is the standard of care owed by a polyclinic GP different to the standard of care that we could expect, say, from a doctor in private practice, or even in hospital where maybe they have more time to see patients?
Not necessary.
I think the short and direct answer is that the patient expects the same standard of care. And so that standard of care must be delivered regardless of the setting. I can't imagine it being okay, for the standard of care to fluctuate just because a patient can only afford subsidized care, as opposed to, someone with more financial resources who can perhaps go to a private practitioner. Regardless of the setting, I think what the care and the treatment that is delivered the advice or the care that is delivered to the patient should be of the same standard. I understand, the limitations that practitioners or clinicians face in practice. So often, yes, they are pressed for time, but if we go back to this scenario, the impact of the medication vis-a-vis the patient profile is, it's quite straightforward in this case scenario. So the medication and the side effects of this medication would have a bearing on the patient's job and what he does. So I think it's quite straightforward.
Okay, Dave Chuncher, Dave first maybe, would you have anything to add about that?
Yeah, I mean, again, when you asked that question, you were alluding to the Bolam standard, right? Whether a respectable body of medical opinion would concur with this. And again, I want to emphasize what I said earlier, that we shouldn't be practicing medicine, or we shouldn't learn to practice medicine from the law. So even Bolam standard, in my mind, is a poor standard for practice of medicine, right? So Bolam only tells us what is done and what is what is acceptable, but it doesn't tell us what we ought to do or what is the right thing to do, right? So just because you can get off on Bolam standard doesn't mean that is the standard that we aim for. We cannot be aiming for the bottom, right? We cannot aim to just pass. in medicine, we have to aim for excellence, and that is what we teach our medical students. That's what we should expect from the rest of us. So the question is, what ought to we do in a case like this? And if a medication has got a risk of drowsiness and it can impact people in many ways, not just on heavy machinery, it can cause falls, it might cause mistakes, even somebody doing a white collar work, it can cause serious errors in their judgment. I think that if as Prof. Roy said earlier, it's the impact that matters. If this is so impactful, then I think we ought to tell the patients, right? And that's regardless of whether the Bolam standard might get you off, might or might not get you off. It sounds like it won't, but even if it might get you off, we should still do what's the right thing.
Thanks, Dave. Chun Chia.
I think doing the right thing is important, and there probably wouldn't, in this case, there wouldn't be any question in that the patient must be warned about this risk of drowsiness. But I just wonder whether the court will actually look at policy considerations when they decide, because the information that must be delivered, must definitely be delivered by the doctor, because we are part of a healthcare system. Is it adequate if the information is, because the patient collects the medication from the pharmacist? Is it adequate if the institution has mechanism in place where the pharmacist will dispense the advice to the patient? If it's a clinic, is it okay if the information comes from a clinic assistant and with the packaging and the warning that do not operate heavy machinery, medicine may cause drowsiness? And I find it very difficult to accept if this kind of considerations are not taken into account in making a decision, because it's said in that, it brings to mind Fuller's morality of law. For law to be accepted, to be practiced, it cannot expect the impossible from the individual.
Vanessa, perhaps you'd like to comment on that, about the alternatives. Yeah.
So if the risk has been conveyed by someone else, I think then, the patient is aware. So then the duty has been discharged. And I mean, it doesn't have to be discharged by the doctor, the doctor who is the one the patient consulted. It can be discharged by the pharmacist or by a clinic nurse. The most important point is that it's conveyed to the patient. So this brings up, the issue of resources as well. There are a lot of things that can be done to help doctors, right? I mean, from an institutional perspective, from a policy perspective, if we are to give pamphlets, or if we are to stick stickers on the medications, these are all steps that can be done to help the doctors in the limited time they have, and I think it should be done.
Yeah, thank you, Vanessa. So that's, again, interesting, raises the question about also whether, in a known setting like that, when time is very short, for example, in a polyclinic setting, whether, there's an obligation of, forget about legal obligation, I mean, even an ethical obligation for the system to be set up so that, the doctor doesn't think the pharmacist is doing it, or the pharmacist doesn't think the clinical assistant is doing it, right? So there's an understanding about how this process works. I mean, I see you're nodding, but I also see Dave's got, so I think everybody agrees that it probably makes sense to have a system in place. So Dave, you wanted to add something or make a comment?
Yeah, I just made a comment. I just wanted to say that the Noor Azlin case shows how the whole system was found wanting in a particular case of negligence. The other issue is that, when we work as employees in a bigger healthcare system and we are given constraints and we work under institutional policies, there is this concept of vicarious liability. And maybe Vanessa may want to explain it to the audience in a way better than me, so that they understand that you're not left alone in such cases, because as Chun Chia says, we are all subject to real life limitations that are placed upon us.
Yes. So vicarious liability basically is that the employer is liable for the acts of negligence of the employee. So in public healthcare institutions where the doctors and the healthcare professionals are all employed by the hospital, then the hospital is liable for any acts of negligence that the employees, the healthcare professionals have committed. So it's quite different in a private setting, because in the private institutions, most of the specialists actually are not employees of the hospital. But that's in essence how vicarious liability works.
Yeah, we've had people are, the Q&A function is heating up again. I think we can take one of these questions directly related to one of the points. I mean, we did talk a little bit about liability in terms of the system being liable for its employees, but somebody else has posted a question here about, if we don't look at, this manual worker who operates heavy machinery, if it's just any old person, they're not told that, it causes drowsiness, then they fall down the stairs and, break a limb or two. Would there, is the same, so basically we're talking about risks that should be communicated to patients. I mean, even ones who perhaps not involved in work that could cause them injury as a result of being, as a result of taking the medication. So Vanessa, maybe I could just ask you this question, please.
I suppose it also depends. In the scenario that, is put in the question, the student takes the medication and the rare side effects of drowsiness occurs. Well, I suppose, if the student was on medication and was unwell, he perhaps should have been resting at home. And it ultimately depends on whether it can be proven that the drowsiness or, the fall was caused solely by the medication itself. When I read a scenario like that, it brings up questions of contributory negligence, whether the patient himself might have been, not careful or might have in some ways contributed to the fall himself. So it really depends on the full context and the facts of each specific scenario.
Okay, thank you very much, Vanessa. Now, I think that, I think the participants tuning in now will be very interested to understand the limits of what peer professional opinion means, because that term is used in section 37. So if we take that and apply it in this particular case, right? So say, for example, if 5 polyclinic doctors were asked what their practice was, and they said they wouldn't normally disclose this rare side effect, does that mean that the peer professional opinion will apply and the polyclinic doctor will then be, absolved of legal liability if indeed the manual worker had, suffered a serious accident as a result of being drowsy from this rare side effect?
Well, I will just caveat to say, I think in this case, it's clear the risk should have been communicated, but, for argument's sake, what is peer professional opinion? If I was acting or advising the GP, then I would get peer professional opinion from 5 fellow GPs, right? Because that is the most realistic portrayal of what his peers would have done. So, and if that, that is available, and it's because under section 37(1)(b), the peer professional opinion must be logical. So if it crosses that threshold of logic, it's inherently coherent, then I think, an argument can be made that the GP should not be held liable. And when you say peer professional opinion, it's okay if there's another group of doctors or fellow professionals who disagree. But as long as you can prove that some will agree with you and, some would have done the same, then you pass the Bolam test.
Right. So that, again, raises that very interesting question. So in this situation, if we had 5 polyclinic doctors who said, I wouldn't normally disclose, and, we had another 5 doctors who said, and actually we've already, in this discussion, we thought it makes sense that the doctor should disclose, and we found 5 doctors who say we should disclose, then is this a decision that will now fall onto the court based on what the court determines is logical? So is the court the final arbiter of what is reasonable and what is logical?
Yes. So yeah, the answer to that is yes, the court is the final arbiter. A lot will depend on the strength of the peer professional opinion, right? So it's not just a one-liner to say, oh, I would have done the same. The expert peer professional opinion essentially is expert opinion. The expert opinion has to be well argued. It has to be reasoned. that there has to be basis and grounds for which the expert is saying he would have done the same. It can't just be a blanket empty statement. And often, when you have cases of medical negligence, the court does pick apart an expert opinion quite viciously. So you have to make sure that if you're going to rely on peer professional opinion, that your peer professional opinion is sound and that it will withstand scrutiny by the court.
Dave, thank you, Vanessa. Dave.
I just wanted to add that, on top of, being peer professional and meeting the Bolito standard, under Section 37, the peer professional opinion is also subject to meeting the standard of information that a reasonable patient in that patient's circumstances would want to know. So, we shouldn't forget that, Section 37 has incorporated elements of HECOP into it, and that so just peer professional opinion alone, without considering what a patient would have in that position would have wanted to know, may not be sufficient.
Yeah, that's certainly a very good point, right? And for those of you who have, I hope you all have access to the relevant section. 37.1 and 37.2 work together, right? So there is this obligation in terms of how the reasonableness and the peer professional opinion kind of work together. So that kind of brings us to this question about reasonableness, right? So in terms of, there's reasonableness across Section 37 in many different, there's reasonable justification for non-disclosure, but there's also reasonableness in terms of reasonable professional practice. So, so I suppose the question then is, the reasonableness, is it, again, is it peer professional opinion? Is it the court? Is it something else? And maybe I'll direct this to Vanessa first, and then maybe ask Chun Chia if he's got something to something to comment about.
Yeah. So ultimately, reasonable standard of care and whether that has been given is determined by the court. But in deciding what is reasonable, the court takes into consideration peer professional opinion. But ultimately, the court is the final arbiter.
Right. So when there are two groups that are both, so basically when there's two peer professional groups that are taking opposing positions, then it's up to the court to decide which one to accept or is stronger.
Yes.
Right. Okay. Chun Chia, would you like to comment on that?
I think for me, if I were to go back to HECOP stood out because it was, as far as I can remember, the only case where the court actually referred to the ethical code and ethical guidelines. To me, that's a new. And so I think what would probably happen is that the court will actually consider what's the professional standard that's been laid out by the body. And I just wanted to bring, because maybe I may be digressing a little bit from this webinar. I know this is a discussion on Section 37, but we also need to consider professional standards or the practice that's set in by the SMC. And maybe I can even ask Prof. Roy Joseph his thoughts on this. We have often hear, gotten reminders and even through the media that a patient's occupation is actually important in the assessment by a doctor because it impinges on the duration of medical certificate, the MC, the rest period that the patient is entitled to. So rather than just looking at Section 37 in isolation, I think we also need to tie in the fact that there's also this other ECG professional guidelines and standards that's out there, and which I think the court will also consider.
Thank you, Chun Chia. Roy, did you want to?
Chun Chia, there's no doubt about it. And I think this is something that has come up during this morning's. What is the standard which all physicians are expected and required by their peers to function at? So that's one. So our peers, we ourselves have a requirement on each other. Then society has an expectation of what we should be doing. And the law has a particular way of ensuring that societal interests are protected and met. And the professionals themselves have an equally important interest to ensure that the profession's reputation is maintained. So there is no doubt that if you understand the ethical code, you will generate ethical code and also the guidelines. In fact, understand the code first, because the guideline is purely to help you keep to the code. So actually, we sweat about Hitchcock and Section 37. We should be sweating about the code. Because if we understand our code, everything else is chicken feed, nothing. You're way above it. Okay? So I think that's the thing. So our guidelines are very clear. And these are based on primarily on, one is a professional perspective, but importantly, it is on ethical values and principles. See, what is the respect that you're giving to this patient? By prescribing something, and they're not telling them that, look, once in a while, people who take this may just fall down and hurt themselves. So here we come to about not only impact, but actually the impact on daily life and the imminence. We spent some time talking about the likelihood of dialysis, which might occur 5 months from today, not tomorrow. And we already felt that that should be maybe important understanding. And if I take a medicine today, and I might become drowsy in 3 hours' time, and as a result of me becoming drowsy, something could happen to me, there should be no doubt in anybody's mind that the patient must be warned. Somehow. It's a second question, who is going to do it? But you cannot say, I will not warn you, I don't need to warn you, because it can occur, and if it occurs, you don't know where this patient is going. So sometimes you can see it's all these common, frequent interactions involving interventions that are everyday interventions that actually create, that are probably more dangerous than these esoteric events that occur in subspecialty and all these sort of things. Yes, every day in Singapore, there probably must be at least 1,000 patients who are prescribed some form of medications for a respiratory infection that probably may cause drowsiness. And if it doesn't come with a warning, we are shortchanging our population. That is my take on this. And anybody who chooses not to do that, if you come before the tribunal, almost no excuse. Because it doesn't take long to have a policy which says everybody who gets his medicine will have a red label saying, warning. That's enough. We have done our job. That's what Vanessa was saying. And that's really our challenge. The physician doesn't need to do everything, but the physician knows, and the physician must ensure that steps are in place to ensure that what patients need to know are brought to them in an efficient, effective, reliable manner. And if we do that, then we don't have to worry too much. And there was a question there, I think question coming is provided that the obligations on the system as a whole, to what extent should the physician herself be liable? It all depends on what is the system that the physician has helped to create to ensure that the advice is reached. If you know that all these things can happen and you don't do anything, then you cannot just blame only the dispenser. The highest liability will probably be on the physician, isn't it?
Thank you, Roy, for refocusing our minds on, putting the patient at the center of care and thinking about it very much from the critical, important information that needs to be conveyed to the patient. So since you brought in one of the questions that have been asked from the audience, we'll just continue on to that one to ask Vanessa, from her legal perspective, right? So actually, I know that another question is showing on the screen. I was thinking of the question before that, actually, which was about the system question that Roy just raised. So the participant wanted to know, provided that the obligation is on the system as a whole, to what extent should the physician herself be liable for failure to inform? So, but I think we kind of addressed it a little bit, but Vanessa, just to make sure that, this point comes across, that there is a systemic, there's a system responsibility, but there's also a physician responsibility, right? So maybe you want to just clarify that point.
What I would want to say is that, this blaming between the system and the physician should not bother the patient, or should not be a burden that the patient has to, cross. That should be something that is worked out behind the scenes, between the institution and the healthcare professional. So if the patient has not received reasonable standard of care, then I think the patient should be compensated. The patient should be able to, receive what he or she should receive in terms of compensation. As to who pays that compensation, if the physician feels strongly that it's a systemic failure, then that's something that we work out behind the scenes with the institution. Practically speaking, because sometimes most of the time the risks are separate. So there are different insurers for the institution and for the doctors. But when we handle medical legal cases, all that is behind the scenes. It's not for the patient to say, oh, I got to sue everybody who was involved in my care. I got to satisfy the different chains so that I succeed in my claim. I don't think that is how, for policy reasons, we can allow healthcare claims to be conducted. So vis-a-vis the patient, if standard of care is not met, the patient should receive compensation.
Okay, thank you, Vanessa. Moving on to, extending our discussion also about reasonableness. We've had a question from the audience specifically about this, and this was the question that was actually flashed just a short while ago, which is, given the court explicitly set aside concerns of cost implications in HE-COC, in para 85 actually, would we expect cost-related time constraints and the effect on the system if more than 10 minutes are required for a consult not be relevant in the interpretation of reasonable excuse for non-disclosure in section 37(2)(b)? So I know this is not an easy question. So Vanessa, shall I ask you first to comment on this?
The first thing that I need to say is that I'm actually looking at paragraph 85 of HE-COC. When the Court of Appeal talked about cost implications, it was in the context of practice of defensive medicine and the court being concerned that we shouldn't drive up healthcare costs. But in that context, the court also came to the conclusion that there's an absence of that in Singapore, or it is not yet a concern. Of course, whether that is the right conclusion is a separate matter for discussion another day. But when the court, talked about these cost implications, it is in the context of defensive medicine, not so much in the context of whether it should impact standard of care. So, but if you're asking me, should time constraint impact standard of care? It goes back to my earlier response that I think the patient expects, that the standard of care should be met and expects that he will be treated, or he will be given the advice that he is supposed to receive. So, if it's 10 minutes, then within that 10 minutes, I think the clinician has to cover all the material points that the patient would want to know.
Well, thank you, Vanessa. Chunche, would you have anything to comment on that point?
I think, okay, for Hitchcock mentioned about healthcare constraints and resources. I think these considerations come into play not in the substance, but in the form of the information. So the substance meaning what the content that needs to be made known to the patient, but the form of delivery, meaning is it done by the doctor himself, or can it be something that be delegated or asked from somebody in the healthcare system, be it a pharmacist or a nurse, a discharged nurse, or somebody who works at the counter. So I think that's pretty important. And again, it boils down to my earlier point that I think it comes to practicing and executing. There has got to be a theory as well as policy consideration and theory. The morality of law, we must not ask what's impossible from the individual, and policy consideration has got to marry this theory and come up with something that can actually be implemented.
Thank you, Chunche. Dave?
I'm not going to talk about it from the legal perspective, but I'm thinking about it from the practice of medicine. And I'm also linking it back to the previous question on, talking about, do we need to disclose all rare side effects and so on? And I think, increasingly, the need for more explicit and more specific consent has come about almost as a reaction to Hitchcock and possibly in the soon to be implemented Section 37. And again, it becomes an impossible task because, how much should we tell? Should we tell them of all the side effects, all the rare side effects, all the serious side effects? There's no end. And it's not only about risk, some patients are interested in the type of anesthesia, type of prosthesis used, brands of treatment, all of these things are potentially things which are relevant and potentially material to different patients. And I guess my response to people who are worried about this, or clinicians who are worried about this, is going to be the same, that you need to learn how to build good relationships with your patients and understand what's important to them. And this is where, if we are focused on narrow biomedical outcomes, then if you want to deliver something within 10 minutes or within a single consultation, it becomes very challenging to meet these standards as well as to deliver those outcomes. But to some patients, yes, curing their thyrotoxicosis or settling their upper respiratory tract infection is the most important thing, in which case the biomedical outcome predominates. But to other patients, it might be that they want information, they want to learn, they want to know a lot of things, and they want to be deeply involved in the decision making, in which case maybe one clinic session is not going to be enough, and they need to come back for subsequent clinic sessions. And they need to understand there will be a trade-off between the amount of information you want, the amount of information you can potentially process, and the practical ability to deliver that information within a set time. Similarly, other patients may prioritize, I want to get the treatment done as soon as possible, and again, some basic information may be required that is covered. But beyond that, they may not want to get a whole lot of other information, and they may be very heavily guided by their clinicians. So, which is why practice of medicine is a continuous exercise of judgment. Just as the practice of medicine is not a cookbook, in anyone asking for one answer to whether or not we should disclose this or that in any given situation is never going to come up. And even the law will tell you it depends. It depends on the context of the case. So that will be my response to these cost considerations. There will definitely be trade-offs. Patients, nobody can expect a lot of information to be given in a very limited amount of time, and there be no trade-off, even in terms of understanding, right? So and I think we just need to be if patients. If we get a sense that the patients want to have all this information, we just need to make sure that they understand the trade-offs. The surgery may be delayed, or the procedure may be delayed. We need to discuss more before we can make a decision together.
Yeah, thanks, Dave. I think that sounds like very good advice, and not just from you, but also from Vanessa and Chunche and Roy as well, right? There's very often for a lot of these issues, there's no kind of plain, simple one-line response or answer. we do have to look at the context and the circumstances, and there are quite a lot of factors that need to be considered and weighed. But as Professor Joseph rightly pointed out, patient safety concerns are something we need to take very seriously, and putting patients at the center of care is a very important aspect. Now, just looking at the time, I think we're doing very well. Now, we've got a little bit of a wrap up, and we have some feedback questions, which we're probably going to put on for participants to answer. Only 2 questions, very straightforward. But before we do that, I'd like to ask Professor Joseph if whether he's got a final question or whether you'd like to make any comments, closing remarks about this case.
Not so much. I think there's the question 18.
That's
excellent. Important. That's, I think, it's a very factual thing, and maybe we should do that.
Okay, excellent. Oh, yes. Thank you for pointing that out. I missed that one. Okay, question 18. We've got a couple of minutes, and I think the audience will be very interested in the answer to this question. Must peer opinion be taken from healthcare professionals in similar circumstances or under similar institutional policies? So, for example, peers of a polyclinic GP can only be other polyclinic GPs, or can peer opinion be taken from private practice, or is there a conflict here? Maybe we can start with Chun Chair, if that's okay with you. What are your thoughts from the clinical perspective? And then I'll move to Vanessa and then maybe Dave, if that's okay.
I think maybe the question, what will determine that will be the question that needs to be answered by the court. If it comes to, for instance, if it's about standards, it shouldn't differ between the professional, the type of the standard of the results, the outcome of a procedure. It shouldn't differ between a private practitioner as compared to one in the public sector. But if other questions where it involves the way information is conveyed, as we have been discussing about in the drowsiness case, I think then where the professional opinion will probably differ between someone coming from the private sector or compared to one from the public hospital. And that's where I think the court will probably have to decide on the kind of the weight to be placed on each type of professional opinion.
Thank you, Chuncha. Certainly the policy considerations are something that quite a few of us have been flagging. Vanessa.
Yes. So I don't think peer professional opinion has to be limited to professionals in strictly similar circumstances. So actually, this is a question on legal strategy. If I can find peer professional opinion from 5 polyclinic GPs, I would present that. If I can find peer professional opinion that is supportive from 3 private practitioners, then I would use that, because I would argue that, this meets the standard of care even for private practitioners who have the luxury of time. So it's really, there are no limits to what peer professional opinion a practitioner can rely on. And I just wanted to make a closing point. With the new Section 37, expert evidence or, peer professional opinion returns to the forefront. And what it means essentially is that each and every healthcare professional plays a part, in determining the standard of care. So I would really want to urge everyone to play an active role in doing so, be it by providing expert opinions or, commenting on whether you think it should be done or what went wrong or what didn't go wrong. Everyone has to say something, right? You can't just not say anything and then later on complain, oh, the court doesn't get it, the court doesn't, the judges just sit there, they don't practice medicine. But with peer professional opinion coming to the forefront, this is the chance for, healthcare professionals, the ball is back in their court, to play an active role and contribute to determining what that standard of care is.
Thank you, Vanessa. Dave.
I'm not sure what I can add to that. Maybe I will say that I think when we are providing expert opinion, please make sure that that it's meaningful opinion, because sometimes a lot of the expert opinions that are provided end up either tending to be unsubstantiated claims or research papers. And as Lim Lenan case pointed out, expert opinions need to be focused on what is practical and what is the standard that should be set in that case, and what kind of information the patient would have wanted to know and why. And if experts don't give good opinions, then we'll get in trouble on the litigation side. And I think that it is good that Academy of Medicine is increasingly rolling out expert witness courses, and I would encourage more and more people to attend those courses, so that, as Vanessa said, if we're going to play an active role, we should play an informed active role in this process.